Today I want to share a story with you about the time that I actually had to withdraw as an attorney in a medical malpractice case. You want to learn what this is all about? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Now, when a new client comes to me and I'm interested in the case and I make a decision to meet with the client, I will invite the client in and we will spend at least an hour talking about all the details of their case. I need to know every single detail that happened. Importantly, I want to understand what they think was done wrong and what injuries they suffered as a result of that. Now, you should know something. Most injured patients don't have a clear understanding of exactly what may have been done wrong. And that's perfectly okay, and nobody expects them to know specifically what exactly was done wrong. They may know that they went to the hospital, they were able to walk, and they come out unable to walk. They're paralyzed. Or they may have some other indication that something was done wrong during the course of their hospital stay, or procedure, or medical care and treatment. So now I spend a great deal of time with them. In addition to that, if after that discussion I still feel they have a valid basis for a case, I can't go right ahead and start a case for them. It's not like a car accident case. In a car accident case, if they came to me and described what happened in the accident and they were a passenger and they had nothing to do with causing or contributing to the accident, then yes, I could start their case the next day, but not in a medical malpractice case. So now, after meeting with this potential client for at least an hour, maybe an hour and a half, now I have to go ahead and start obtaining and gathering all the necessary medical records. Why do I do that? Because I have to know for myself exactly what occurred. I have to try and identify in those medical records exactly what happened to this particular patient. Now, is that enough? No, it's not enough. The law in New York requires that I go ahead and get a medical expert to review those medical records to determine whether or not the doctor who's involved, or the doctors or hospital staff, violated the basic standards of medical care. Now, is that enough? No, that's not enough. My expert has to determine that if the doctor or hospital staff violated the standard of care, they were careless, whether that carelessness was a cause of your injury. It doesn't have to be the cause, it only has to be a cause of your injury. And then, if there is that connection, lawyers call that causation, if there's a link between the doctor's carelessness and your injury, now we have the bridge that connects the wrongdoing with your injury. Is that all? No, that's not all. There's more. Well, what else does the expert have to look at? The expert has to see how extensive your injuries are. Are they disabling? Are they permanent? Will they affect you for the rest of your life? Are they going to affect your ability to do your daily activities? Will they affect your ability to earn an income? If the answers to all of those questions are yes, 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 and yes, well, now we're talking. And now my expert comes back to me and says, okay, you've got a basis for a case. And I call you up and I tell you, okay, my expert has confirmed that you have a valid case. Now I'm going to go ahead and prepare the documents necessary to start your lawsuit. So what does that have to do with the title of this video about me withdrawing as the attorney on this particular medical malpractice case? Actually, it has everything to do with it. During this initial consultation, this potential client told me a lot of what went on, as well as what damages and what injuries he suffered. Okay? Now I am relying on him for this information. Is that enough for me to go ahead, once I learn that the medical expert has confirmed he has a case, to go ahead and assert those damages? The answer is no, it's not enough. Why not? Because I have to verify. I have to verify that what he's saying is true. You know the phrase, trust but verify? That's exactly what I have to do. And I do that by getting all of his subsequent treating medical records, which means all of the doctors with whom he is treating with now, I need those medical records. I need to see what problems he has, how often he's gone to the doctor, whether he goes to rehabilitation, whether he has physical therapy. I need to know what complaints he's making. Importantly, I also need to know and need to speak to his treating doctors to see whether or not they believe his injuries are permanent and long-lasting. So what's the problem here? The problem is that every time I would ask this gentleman for copies of his tax returns and his W-9 forms, he kept pushing me off. He kept telling me he couldn't find it. He kept saying and giving me one excuse after another. When I went ahead and filed this document called a complaint, which starts the lawsuit, there's nothing in there that permits me or requires me to itemize the damages at this point. So what's the big deal? During the course of the lawsuit, I am obligated to prepare another document called a bill of particulars. In that document, I am required to itemize. Well, first of all, I have to itemize exactly what the claims are in the case, what it is that we believe the doctor and the hospital staff did wrong. And I have to go into very specific particularity, meaning I have to identify and let the defense know exactly what our claims are. If I don't do that, they're going to be prejudiced because they won't know what this claim really is about. So I have to explain to them in exquisite detail, based upon my expert's evaluation, exactly what we believe was done wrong. The doctor failed to do X, Y, and Z. The doctor failed to do this. The hospital staff failed to monitor. They failed to do this. And as a result, this patient suffered all the following injuries. And had they done A, B, and C, none of these problems would have occurred. Okay, in addition to that, we have to set forth exactly what damages this patient suffered. In addition to pain and suffering and the need for rehabilitation and additional ongoing medical care and surgical care, we were also claiming financial losses, loss of income, loss of past income, as well as lost future income. Now, in order to do that properly, I needed to obtain his tax returns, I needed to obtain his W-9 forms, I needed to obtain his W-2 forms, so that I could verify that this guy did in fact have these various financial losses. Okay, so now what happens? During the course of this lawsuit, my client was questioned in a pretrial process called a deposition. It's a question and answer session that's given under oath. And in this instance, it was done in my conference room, in my office, and the defense attorney was there, and a court stenographer was there, and my client was asked hundreds and hundreds of questions that day. The answers that my client gave in my conference room carries the same exact weight as if he was testifying in court at trial in front of a judge and in front of 6 members of the community known as a jury. My client was asked questions about his damages and about his financial losses, and he proceeded to go ahead and describe all the financial losses that he claims to have suffered. Now remember, at this point, I still had not received tax returns. I still had not received the W-2 forms or the W-9 forms. And I keep asking him, and he keeps giving me one excuse after the next, after the next. So now, because we are claiming these financial losses, I am obligated to provide copies of them to the defense. Because my client was self-employed, I was required to provide them with copies of my client's tax returns. Not just his W-9 forms, not just his W-2 forms, but his tax returns, so that they could analyze them to evaluate whether or not this guy did earn a certain amount each year, and now because of his injuries, he now has all of the following losses. Great. So here he is, he's testifying at length about all the various financial losses he has. The defense afterwards says, hey, we need an authorization, a permission slip, to get these documents directly from the government, and we need you as the attorney to provide us with copies from your client. So I'm on the phone with my client, I need these documents, I need these documents. And he keeps giving me one excuse after another. Finally, the defense attorney calls me and says, hey, Gerry, I don't understand. We've been asking you for his tax records for months now. What's the deal? And I tell him I'm trying to get them. We have requested them repeatedly. My client is looking for them. He had a flood in his office or whatever other excuse he came up with. And now I'm simply relaying this information to the defense attorney that we will get them and provide it to him. Now, he asks, why haven't I given him authorization yet to get it directly from the government, to get it from the IRS? I said, I'm waiting for my client to sign the authorization and then you'll be able to do that. So what's the problem? Why all this big long-winded explanation? I'll tell you why. Because when I finally got my client's tax returns, the information contained in there was a lot different than what he had told me at the very beginning. The information that was contained in his tax records were significantly different than what he testified to during the course of his deposition. This wasn't a case where he simply forgot 1 or 2 facts or 1 or 2 figures. This was something that you could say he outright lied. Or, to put it in a more polite way, he told an untruth, a convenient untruth. Why would he do that? Because he was trying to hide certain things he had done And now this was all coming to light because I kept asking for these tax records. He knew that if he had released these records, he would have gotten into significant trouble with various governmental organizations. I told him he destroyed his entire credibility. I said, now that you've already testified about all this, you are obligated to provide this. If you fail to do so, now they're going to make a motion to the judge to preclude you, to prevent you from doing this. And you know what? They're going to know that something is up. They're going to subpoena those records at the time of trial. And then they're going to ultimately realize that what you testified about was actually not correct. And they're going to dig and dig deeper. And now they're going to use everything they can possibly find that you have contradicted against you at the time of trial. And you might be thinking, what does it have to do with the facts of the case? Well, I'll tell you what it has to do. It has to do with your credibility. And if you, the injured patient, are not credible, you've got a major problem. And the reason why I had to withdraw as the attorney in this case was because I could not ethically continue forward representing him. Why? Because I had now learned that he had testified falsely, intentionally, for the purposes of hiding those issues he had with his income. And because of that, I could no longer represent him. So what did I do? I had to file a motion, which is a written request to the judge to take some form of action. Now, I am prohibited from an ethics standpoint from disclosing the specific reason why I am asking the judge to be relieved as the attorney in the case. Why? Because I'm not permitted to disclose that to the court. If I did, my opponent would clearly know every detail of that. And that I am not allowed to do. So instead, I have to be very vague, but everybody who's involved pretty much knows what's up. They know that there's an issue that comes up. They know that there's a credibility problem. The judge knows it. He doesn't have to ask the details. The defense will know it. And then at some point afterwards, the judge will allow me, and did allow me, to go ahead and be relieved as the attorney on this particular case. So why do I share this information with you? I share this story with you just to open your eyes, to show you and explain to you how important your credibility is in these medical malpractice cases, these accident cases, and even the wrongful death cases. Your credibility is everything. You know, I recognize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.